So I wanted to talk a little bit about guardianships in Massachusetts and some of the terminology and options in guardianships, particularly guardianships of a minor. There's also guardianships of incompetent as well, but here's mainly talking about guardianships of a minor. A proposed guardian can go in, there's a petition to file a guardianship, and you have to put down the reasons for that. You can do that generally in probate and family court, but in certain circumstances you can do that in juvenile court as well. And at times you can file an emergency motion if there's a true need for an emergency. So you can try and walk in a guardianship and the related paperwork. And so an emergency guardianship would be that day or in a very quick time, sometimes without even notice to the parents, that there's a real dramatic need, basically an emergency, to get that emergency guardianship. That generally is only valid for a few days or maybe a week, and then you would go in for something called temporary guardianship. Temporary guardianship is not permanent, which you can tell from the phrase temporary. And there would be a temporary hearing for the judge to determine whether it's contested or not, whether you would be an appropriate potential guardian, and if so, if the parents assent or oppose it, or if you gave notice and the mother assents, but the father's hasn't been served. So there are a variety of different things. And then the case will get marked up for a hearing which will be a determination of permanent guardianship. Permanent guardianship, though, in probate court generally does not mean that the parent's parental rights are terminated. It can occur, but that's usually a very, very minority of cases. So permanent guardianship means is that there would not be any further court dates unless the parents filed a motion to vacate the guardianship and have to explain what the reasoning is for that. So for example, if they had substance abuse issues and showed that they were clean and sober and got treatment and that they were currently fit parents and can care for their child, they could do a motion to vacate the guardianship. An adoption is something that you do need termination of parental rights, and many times people have a guardianship first and then an adoption afterwards. Sometimes in juvenile court, there will be guardianships without parental rights being terminated, but many times DCF or the courts will want, if you're filing for temporary guardianship or permanent guardianship, will want the parents' parental rights to be terminated. These are things that can be negotiated, and advantages and disadvantages, but it's important to understand what court that you're in, the terminology, and the choices that you have. Many times parents are actually willing to sign a stipulation to permanent guardianship. I would say probably the majority of cases that I have, at some point or another, the parents do not contest the guardianship. Many times they understand that they have substance abuse issues, or they don't have an appropriate place to care for the children, or they have their own issues that are going on. An attorney can prepare a stipulation for permanent guardianship. They can have the parents sign, or even just one of the parents sign, that can make it less than having a full-blown hearing. If things are contested, though, it's a similar trial to a custody trial, where there's a burden that the proposed guardian would have to show that the parents are unfit, unavailable, or unwilling to be able to parent their child, and you have to show that currently as well. So there's a variety of steps that you should go over with an attorney if you're considering guardianship and determining whether or not you're looking for an emergency, temporary, permanent, and whether or not it can be negotiated or would need to have a hearing.